Picture this. It's a gray Tuesday morning in March 2026. Robert Delgado is standing in his driveway in Scottsdale, Arizona. He's 74 years old, retired electrician, 31 years with the same union local. Behind him, the house he paid off in 2009, 3 bedrooms, a lemon tree his late wife planted the year they moved in. In his hand, a letter from the Arizona Healthcare Cost Containment System. That's Arizona's Medicaid program. He doesn't open it yet. He just stands there. Because 6 years ago, his daughter Melissa sat at his kitchen table with a notary and a stack of paperwork and told him this would protect the house. "Dad, we just add my name to the deed. That's it. That's all we do." It felt simple. It felt like love. It felt like the smart thing to do. Robert signed. And for 6 years, nothing happened. No red flags, no phone calls, no warning signs until the stroke, until the nursing home bill, $9,800 a month and rising, until Robert sat down to apply for Medicaid to cover his care and found out that the thing he did to protect his house might be the exact reason he could lose it. Here's what nobody tells retirees before they add a child's name to their deed. It's not in the pamphlet the bank gives you. It's not in the article your neighbor sent you. And by the time most families find out, it's already too late to undo it. We're going to walk through exactly what happened to Robert. Real Medicaid rules, real math, real timeline. And at the end, I'm going to show you the 2 different futures for families who own a paid-off home going into retirement. One where this mistake wrecks everything, and one where a different plan protects it completely. Stay with me, because the danger here isn't the nursing home bill. It's what happens 6 months after that bill arrives. Let's go back. 2020. Robert is 68. His wife Carol passed the year before. The house, 2,400 square feet, paid off, worth around $410,000 at the time, is the biggest thing he owns outright. He hears the word Medicaid from a friend at the VFW hall. The friend says something like, "If you ever need a nursing home and you don't plan ahead, they'll take everything. Better put your kid's name on the house now." It's not bad advice because Robert is careless. It's bad advice because it's incomplete. To qualify for long-term care coverage, a Medicaid applicant generally has to bring their countable assets down to around $2,000. That's the number in most states in 2026. So the logic in Robert's head goes like this. If the house isn't fully mine anymore, it can't be counted as fully mine anymore. Melissa's name goes on the deed as joint tenant with right of survivorship. They shake hands. They hug. Melissa cries a little. It feels like the responsible, adult thing 2 people who love each other do. Nobody in that room knows what's coming. Here's what actually gets checked when Robert applies for Medicaid 6 years later. It's not just his bank account. It's not just his pension. It's every asset transfer he made, going back 60 months. That's 5 years. And what he did with that deed in 2020, it's about to walk right back into the room. When Robert applies for long-term care Medicaid in 2026, the state doesn't just look at what he owns today. They pull his financial history back 60 months, 5 years from the date of that application. This is called the Medicaid look-back period, and it exists in this exact form in most states. Every transfer, every gift, every deed change. If Robert had given away money, sold something for less than it's worth, or added someone to an assets title during that window, Medicaid treats it as a transfer that could have gone toward paying for his own care. And here's the part that catches families off guard every single time. Adding a child's name to a deed counts as a transfer, not the whole house, but Robert's share. Half the value, in his case, since Melissa now owns 50%, was effectively given away, for nothing, the day her name went on that paper. Robert's transfer happened in 2020. His application is in 2026. That's outside the 60-month window. By a matter of months, he got lucky on the timing. But here's the second problem. The one that doesn't go away just because you clear the look-back window. Even if the transfer is outside the 5-year window, even if there's no penalty period, there's a second trap waiting. And this one has nothing to do with timing. This is the one that actually takes Robert's house. Here's the piece almost nobody explains clearly. When you add your adult child's name to your deed, you are not removing your ownership stake from Medicaid's eyes. Your interest in that property, your half, in Robert's case, is still counted as your available asset for Medicaid eligibility purposes. Joint ownership doesn't make your share disappear. It just means 2 people now own pieces of the same asset. so the protection families think they're getting when they add a name to a deed. Legally, it was never really there in the way they imagined, and it gets worse after Robert dies. Because Medicaid isn't done at that point. That's when Medicaid estate recovery comes in. States are required to attempt to recover what they paid for a Medicaid recipient's long-term care from that person's estate after they pass away. If the home is jointly owned, some states can still pursue recovery against the deceased parent's percentage interest, even though the property has a surviving co-owner. It depends on the state, but the assumption that joint ownership shields the house from estate recovery is, in a lot of cases, simply false. But that's not even the most expensive mistake in this story. There's a number sitting inside this plan that Robert has never once calculated. A number that could cost Melissa more than the nursing home bill ever did. Let's say, for a moment, none of the Medicaid complications above ever happen. Let's say Robert never needs long-term care at all and simply passes away peacefully at 82, in the house, with Melissa still on the deed. You'd think, no problem. Melissa already owns half. She inherits the rest. Simple. Here's the number nobody in that kitchen in 2020 ever ran. If Robert had left the house to Melissa entirely through his will or a trust, she would have received what's called a step-up in basis, meaning her cost basis for tax purposes resets to the home's fair market value on the date of his death. But because Melissa was added to the deed while Robert was alive, her share of the property keeps Robert's original cost basis, not a stepped-up one. Say Robert bought the house in 1994 for $95,000. Say it's worth $410,000 the year he added Melissa. Her half of that asset carries a cost basis tied to that original purchase price, not the current value. If Melissa ever sells the house, even years later, that gap between the original basis and the sale price could mean a real capital gains tax bill she wouldn't have owed if she'd simply inherited the house the normal way after her father's death. That's not a Medicaid problem. That's a completely separate, self-inflicted tax problem, created by the exact same signature that was supposed to protect the family. And we haven't even gotten to the part where Melissa's own life becomes a risk to her father's house. Once Melissa's name is on that deed, the house isn't just Robert's asset anymore. It's Melissa's asset too, which means Melissa's creditors can now have a claim against her share of the property if she's ever sued or falls into serious debt. It means if Melissa goes through a divorce, her ownership interest in her father's house could become part of that conversation. It means if Melissa dies before her father, which nobody plans for, but which happens, her share of the house could pass to her estate, not automatically back to Robert. Suddenly, Robert could be co-owner of his own house with his son-in-law, or with Melissa's creditors, or with whoever her will names. None of this occurred to anyone at that kitchen table. Why would it? It felt like a form. It felt like paperwork. It felt like nothing. It wasn't nothing. Let's meet someone else. Diane Whitfield, 71 years old, widowed, former hospital administrative assistant, lives in a paid-off home outside Columbus, Ohio, worth about $260,000. Diane's situation is different from Robert's. She doesn't add a child to the deed 6 years early. She waits until she's already had a diagnosis, early-stage Parkinson's, and she's scared. 18 months before she needs to apply for Medicaid, she puts her son Gary's name on the house. This time, the transfer falls squarely inside the 5-year look-back window. Here's the math Ohio Medicaid actually runs, using the real formula every state uses. The value of the transferred interest, Diane's half of a $260,000 home, so $130,000, gets divided by what's called the penalty divisor. That's the average monthly cost of nursing home care in her state, which in Ohio runs roughly $8,000 to $9,000 depending on the year and region. $130,000 divided by roughly $8,500 a month comes out to about 15 months. That's 15 months where Diane is medically and financially eligible for Medicaid, and Medicaid still won't pay a dime toward her care. 15 months of a nursing home bill, completely out of pocket, at roughly $8,500 a month. That's over $127,000 that Diane's family now has to cover. Money that didn't exist in the family's plan because nobody told them the deed change would trigger a penalty period. And the cruelest detail in Diane's story, The penalty period doesn't even start on the day she added Gary to the deed. It starts on the day she applies for Medicaid and is otherwise eligible, which means the clock she thought she'd already beaten hadn't even started ticking yet. Now, there are real, documented exceptions where transfers like this don't cause a penalty, but almost nobody uses them correctly. And the one everyone assumes applies to them usually doesn't. The spouse exception. If you transfer your home to your spouse, there's no penalty. Full stop. The caregiver-child exception. If an adult child lived in the home for at least 2 years immediately before a parent entered a nursing home, and that child provided care that allowed the parent to stay out of a facility during that time, the home can sometimes be transferred to that child without a penalty. But the requirements are specific. Documented residency, documented caregiving. The sibling exception. If a sibling already has an ownership interest in the home and has lived there for at least a year before the applicant entered a nursing home, that sibling can receive the applicant's interest without triggering a penalty. The disabled child exception. Transfers to a child under 21 who is blind or permanently disabled generally don't trigger a penalty either. Notice what's missing from that list. I added my healthy adult child to the deed because I was worried is not on it. That's the exception families assume exists. It doesn't. So if joint ownership isn't the answer, what is? I'm not a lawyer, and this isn't personalized legal or financial advice. Every state runs its Medicaid program a little differently. But here's what elder law professionals consistently point to. An irrevocable Medicaid Asset Protection Trust, set up more than 5 years before care is needed, removes the home from your countable estate entirely, while still letting you live in it. The trade-off is real too. It's irrevocable, meaning you give up direct control, and it has to be done well ahead of a health crisis. A properly structured life estate can also work in specific situations, but this still runs on the same 5-year clock. Long-term care insurance, purchased while a person is still healthy, is another route entirely, one that sidesteps the Medicaid maze altogether. The common thread in every option that actually works: time. Every one of these strategies loses its power the closer you get to actually needing care. The 5-year window isn't a suggestion, it's the whole game. But the biggest mistake in this entire story hasn't happened yet. It's not the deed. It's not the penalty period. It's not even the tax bill. It's the conversation that never happens, until the letter's already in someone's hand. Let's go back to Robert, standing in his driveway with that envelope, Future 1. Robert opens the letter. It confirms what he feared: a partial denial tied to that 2020 deed change, plus a request for 5 years of financial records he now has to track down from memory. Melissa spends the next several months buried in paperwork, arguing with caseworkers, trying to prove a transfer that felt so simple back in 2020 wasn't an attempt to game the system. Legal fees stack up. The house, the one thing this was all supposed to protect, sits under a cloud for the rest of Robert's life, and Melissa inherits not just a home, but a tax bill tied to a basis that never stepped up. Future 2, same house, same family, different year. In this version, Robert sits down with an elder law attorney in 2020, not a friend at the VFW, not a well-meaning neighbor, an actual professional who does this for a living. They look at his health, his assets, his timeline. They set up an irrevocable trust that same year. 5 years pass uneventfully. When Robert has his stroke in 2026, the 5-year clock has already run out. The house isn't in his name. It's protected, fully, cleanly, with no penalty period, no estate recovery exposure, no basis nightmare waiting for Melissa. Robert gets the care he needs. Melissa gets the house her father wanted her to have, free and clear, exactly like he intended in the first place. Same love, same intention, completely different outcome. The only difference between those two futures is 5 years, and one honest conversation with the right professional instead of a kitchen table shortcut. If you or your parents own a paid-off home and you've ever thought about just adding a name to the deed, stop before you do anything else and talk to an elder law attorney who handles Medicaid planning in your specific state. Rules vary state to state, and the version of this mistake that hits a family in Ohio doesn't look exactly like the version that hits a family in Arizona. This channel exists to walk you through exactly these situations. The ones nobody explains until it's too late. If this helped you see something in a new way, subscribe, because we're covering the next Medicaid trap next week. And it's one that catches even families who did everything else right.